Today, I'm going to talk to you about how you prepare your own last will and testament. But before I tell you how to do it, I'm going to ask a question. Should you do it? Actually, I'm going to answer that question, not just ask it. You are certainly able to prepare your own will, but a little word of caution. That is that every will contest I have ever seen come through the courts or come through my office has been based on a will that was either handwritten or done by someone using online software without the assistance of an attorney. Now, I'm no longer practicing law, so I'm not saying this so you hire me, because I'm not hireable to prepare your will. But I just want you to pay attention to the fact that you don't know what you don't know when you're doing a will, certainly for the first time, and that if you end up with a will that is vague or incomplete, you could be setting your estate up for a will contest after your death. So just be cautious about this. Certainly do your homework, listen to this video, watch this video, do some reading up in your state on what the state law is in terms of how you do your own will. But if you decide to draft your own will, because maybe you're in a hurry, you're going on a trip, you just need something in place to tide you over until you can get to your attorney, the purpose of this video is to tell you what should be included in your will should you do it yourself. Now, another question that comes up is, can you handwrite a will, or does it have to be typewritten with the formalities of witnesses and a notary? Well, the answer is that depends on state law. Many states will allow you to do a to do a will if it is in your own handwriting. That is called a holographic will, HOLOGRAPHIC. So you want to go to your state's law and look up whether a holographic will is valid in your state. If it is, then the will needs to be entirely in your own handwriting. And if you do that, then you just title it a last will and testament. You have a paragraph where you declare it to be your last will and testament. I, Mary Hart of my county and state, declare this to be my last will and testament. Then you write what you want in the will, and then you date it and sign it. If it's in your handwriting, and if your state law allows that, you do not need witnesses or a notary. So let's talk about a will if you're doing it not in your own handwriting, but you're doing a typewritten will. In most states, you don't need witnesses or a notary. Well, let me back up. You don't need a notary in most states to make it valid, but what you do need a notary for is to make it self-proving. And we'll talk more about that in a minute. But you want to have a notary so that you don't have to go prove that the witnesses actually signed the document or that you signed the document. So for the sake of this video, we're going to assume that you're typing your will, whether that's free typing it yourself or using some sort of software, and that you're going to have at least 2 witnesses and a notary. And so I'm just going to talk to you about what are the contents that you should put in that will. So the first thing you're going to want to do is type the heading at the top of the document, last will and testament of, and then your name. So mine says last will and testament of Mary Elizabeth Hart. Then in the first paragraph, you're going to want to say, I, comma, then your name, declare this to be my last will and testament, and hereby revoke all prior wills, last wills and testaments and codicils executed by me. So I, Mary Hart, declare this to be my last will and testament, and I hereby revoke any prior wills or codicils executed by me. Period. The next paragraph, I usually like to describe the family, who your loved ones all are, what the law calls the natural objects of your bounty, which I think is a very funny term. So I will say, for instance, I am married to Frank Mocase Hart. My children are, and I will list the names of my children. And I'll probably put their birth dates in there, or at least the year of their birth, so that people know whether they're minor children or not. I don't always put the full birth date anymore because of identity theft issues, but I might say born in such and such a year. I will probably list my stepchildren because I have them. The next paragraph, I will direct my personal representative, that's the word we usually use for an executor now, direct my personal representative to pay all my just debts and taxes out of my estate. And then I will go into any specific bequests I might want to make. Now, what do I mean by that? Let's take personal property, the stuff, your artwork, rugs, furniture, jewelry. I might want to leave certain items of personal property to certain people. So my next paragraph would be items of tangible personal property that I'm leaving. I might want to say I will leave a list with my will, and I will list those items that go to certain people on that list. But then I'm going to want to say anything not on that list goes as follows, and put something in there. After I've left my personal property, maybe I want to leave some specific bequests of cash or cars or stocks or anything like that. So I would describe the name of the person and then describe the asset that is going to that person. So for instance, I might say, I leave my car to my son, Will. I leave my bank account number, blah, 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 to my son, Chad, whatever it is. So you have another paragraph with other specific bequests that are not personal property, not the stuff. After you've done listing out all the specific things you want, it is very, very important that you have a paragraph that leaves what we call the residue of your estate. That's everything that you have not already left to someone. We call it the rest, residue, and remainders. That's the safety net that gathers up everything else that you have not specifically listed and leaves it to somebody or to multiple people. So I would say something like, I leave the rest, residue, and remainder of my estate, whether real property or personal property, and wherever located, as follows. And then I'd put in my provisions, whether I'm leaving that to my children, to my husband, to charities, to some combination thereof. I just want to make sure that I have that residuary clause, is what we call it, the residuary clause in your will, to make sure that as you go through life and you gather up assets, you don't have to change your will and add every single asset into your will. There's this safety net clause that gathers everything up and leaves it, anything that is not already specifically bequeathed in your will. Very, very important paragraph. Once I've done that, then I, of course, want to name my executor or executrix. These are the old terms. We usually call them your personal representative now. I'm going to name one at least. I might name co-personal representatives, but keep in mind that that means both people have to sign, and that becomes a real pain. So you only want to name multiple personal representatives if it's really, really important to do so. So I'm going to name my personal representative. I'm going to name a successor. It says something like, in the event that Frank Hart is not able or willing to serve as my personal representative, then I nominate and appoint my son Will Zemp as my successor personal representative. And I might do that 2 or 3 times, depends on how long I want my list of successors to be. If I have minor children, then I would want to name a guardian and a successor guardian. Right? And I've had some cases where a client has been divorced and they do not want the children to go to the other parent without some court or agency determining that that other parent is fit to raise the children. We have put that in wills before. So we've named our executor, we've named our guardian. If we've left anything in trust for someone, then we obviously need to name a trustee and successor trustees. We want to put in the fiduciary powers. A fiduciary would be your personal representative or your trustee. What powers do they have? Usually we want them to have all the powers available under your state law, and then we might want to enumerate some, specifically including but not limited to the following powers, just to make sure that your fiduciary has the power to do anything that is necessary to administer your estate. And then, of course, you want to date it and sign it in front of 2 witnesses. And then there's the notary will come in and notarize the signatures of you and your 2 witnesses. And there's particular language that you want in the will that makes the will self-proving, so you don't have to, so your estate or your personal representative does not have to go to court to prove that that is your will, that those signatures are by legitimate witnesses and you, because the notary has basically done that. So you might want to Google self-proving language for wills to see what that is. But that's basically what you want in a simple will. And of course, we can get way more complex than that, but that's the bare bones that you want in a will. So I hope that helps you. And again, it's not always the best thing to do this yourself at home. You can forget something or be vague, and then it becomes unenforceable and your wishes are not carried out. So if you're going to do your own will, please research it thoroughly. Make sure you know what you're doing when you do it. Best of luck.